Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our community conference call where everybody's welcome to join in. We do it every other Thursday. First, I will answer all the questions that have been posted on our forums.immigration.com, and then we'll take follow-up questions on the forum questions, and then we'll take new questions. That said, let me get started. First question is from Raj IMG, who wants to know how much time does it usually take after fingerprinting to get EAD, advanced parole, and then green card? Well, EAD AP is not connected with your fingerprints necessarily. EAD AP, the rule of thumb is, or at least the target that the government goes by is 90 days within filing, they want to approve the EAD AP. Green card is widely different. If your case gets stuck in some kind of a background check, it can take a very long time. Okay, most people can expect some movement if the priority dates are current within a few months. Some people who are pre-adjudicated, there's something called pre-adjudication. You can expect something even earlier. So it all depends. It's too many variables for me to make any good guidelines for the time it takes. Okay. Then, since I'm on H-1B, can I continue current job and maintain H-1B and also take employment on EAD? No. If you take employment on EAD, your H-1, for the lack of a better term, goes to sleep. You can revive it by leaving USA and coming back on H-1 visa, and then you're back on H-1. But if you use EAD, then you are using EAD for everything. Okay, you cannot have a situation where you're using H-1 for one job and EAD for the other and still maintain H-1. You're on EAD. Okay. Next question is from Sandeep Shukla. Shuklaji wants to know, I'm on a B1, B2, and the visa is good till 2024. Director of an Indian company for the past 20 years. There's a joint venture. They're talking about L1, newly created joint venture with my Indian company and a US company. It's an LLC. What are the basic requirements? Well, that's a fairly lengthy question, Shuklaji. If you had more focused questions, I hope you are on the phone here and you can ask me more focused questions. The very basic requirements for an L1 AR, you must have acted as a managerial or executive level employee for a branch, sister, parent, daughter of the American company for 1 year out of the last 3. Your job in USA should also be managerial or executive. If you are coming to open a new office or start a new business, you should be able to show the government that you have procured premises, etc., and you're ready to start business. And then within a year of the approval of the L1, you will be able to maintain the level of business and staffing necessary to support an L1A level job. Okay. Can I invest money to this LLC? See, the problem, Shuklaji, is whenever we are talking about money being invested into a business venture where in order for you to successfully participate in that venture, you've got to have some kind of visa. Then the problem is you are taking a big risk. What if the visa is not approved? This is true for E1 visas, E2 visas, L visas, EB5 green cards. The problem is you have invested money and all of a sudden you've got nothing. You've got to be very careful with that. So one of the things we recommend to clients who are trying to do an L1A is instead of putting the money directly into the venture, you can put it into an escrow account, so that the escrow will be released if the visa is approved. If the visa is not approved, you take your money home. Okay. once, and by the way, you can file L1 on a premium processing basis. So in a few weeks, you know where you stand. Another issue that you want to discuss with your lawyers at some point is, should I convert from B2L visa, or should I go back to home country or another country and get my L1 visa and come back? So that's another issue you got to be mindful of. It really is not enough time here to go over all the issues. If you had more focused questions, I could have tried to answer them. And your last comment was, will my 20 years experience be counted as minimum 3 years experience of foreign companies, one or not? I'm not sure I understand that question at all. The requirement is that you must have 1 year experience in managerial executive capacity. And then the companies in USA and India should be related. But there's no requirement that the company's relationship should be 1 year old. Okay. So if you buy a company or start a company, you can still qualify for L1 even though you have just started the company. And the relationship between the Indian company and the US company is much less than a year old. No problem. Okay. So I hope that covers up most of the ground that you were trying to. Next question is Dame. Lawyer filed for interfiling EB3 to EB2 a couple of months back, but there's no update on the 485. It's still in initial review. I called USCIS and they are asking my lawyer to talk to them. Well, that's ridiculous, because the 485 is your case and they should talk with you. Okay. So I don't see any reason why USCIS should not talk with you, even though you have a lawyer. You can let them know that you want some information about your I-485. That is your case. Okay. So go back and talk with them. You can also contact your congressman's office or the ombudsman. Ombudsman. What in Hindi is called Lokpal. Ombudsman. O-M-B as in boy, U-D as in doctor, S as in Sam, man as in man, woman. Ombudsman. USCIS has an office called an ombudsman whose job it is to make sure that the public's problems with USCIS get corrected. Okay? If you just Google USCIS ombudsman, you should be able to pull out the information, how to contact them, how to open a case. Moza wants to know, I guess this is a question about DV lottery, I can only guess. So he says, my case number is 2014A something something. I haven't gotten any appointment yet. Sir, I'm very sorry. We don't deal with DV cases, lottery cases, so I have no idea what's wrong with your case or what you should do. Most of these cases don't require a lawyer, so we've never undertaken a DV case. Now, we took one or two first couple of years when DV lottery first started. Then we realized lawyers are not really needed for these cases. Next question is from Houston Krishna, who's got a case going against I guess an employer with the Department of Labor. So DOL is ready to give the case in their favor, but only get 50% of total due back wages. DOL said they can't push the employer to give 100%. You need to go to court for that. I don't know where they get that from. I discussed with my wife. She's not ready to prolong and not ready to go to court. So is it okay to settle for 50%? I mean, that's up to you. I don't see any problem. It's a matter of money. As far as immigration law is concerned, I don't think it's going to cause you any problem in status because you took 50%. It's a settlement. It isn't your salary or your wife's salary. Okay. So as you put it, is it going to bite us in green card processing? I don't think so. And you said currently your firm is doing my green card, so my wife will be dependent. Oh, okay. All right. So I guess we represent you and this is about your wife. Okay. Okay. I'm not worried, Krishna. We'll deal with it. I don't think it's going to be a big problem. As long as we have a copy of the complaint that you filed and a copy of the settlement, we can show that your wife was not getting paid not because she wasn't working or ready to work. It was because the employer was not paying her. So we should be okay. Dhruv wants to know, H1 transfer from employer A to employer B, new employer. I-140 has been approved with employer A. So the first point is, after H1 transfer approval is received with employer B, is it okay to continue working with employer A? The answer is yes. Does that affect H-1B visa status or obtaining 3-year extension? It does not. What happens is, so I'm already working for an employer. My H-1B gets approved. I don't have to join them right away. If you're already in USA, you could easily delay this joining the new employer by about 60 days. If you needed more time, I would suggest you give something in writing to the employer, the new employer, explaining why you cannot join them right away. And I think that time can be extended even a little bit further than 60 days. Okay. If employment with employer B started, is it okay to come back to work for employer A? If you'd asked me this question a few years ago, I would have said yes. But with USCIS taking the position that each time an employee is let go, the employer must immediately inform USCIS and revoke the H1, I don't think that option remains open that easily. So if you start working for B, employer A should revoke, in fact, must revoke your H1. If employment with then it's okay to come back, it can cause any, okay. So that answers those questions. Sarika Guru wants to know about H1 visa. I've got my H1B visa approved by Premium, which is valid from 1st October 2014. Because of maternity reasons, I don't want to start working from October 1st. I decided to file for H4 extension, which is expiring on 30th September. Sarika ji, there is a problem, which I think is a very artificial problem. It shouldn't really be a problem. But USCIS might, and I think they are likely to take the position. If your H4 extension is approved before October 1st, you cannot become quota exempt. If your H4 extension is approved after October 1st, then you would still be quota exempt if you want to go back to H1. Okay. As far as the last action rule is concerned, I have had this discussion with some of the more senior lawyers in USCIS. Nobody quite knows where this last action rule comes from. There really is no legal support for this. Nevertheless, the current thinking is whatever gets approved last would be your status. However, if you get a change of status to H4 before October 1st, I believe you would still be on H4 come October 1st. Okay. So that's my belief. You can double check with USCIS, call them up, make notes on what they say. The officers will typically give you their badge number and their first name. Okay. So make note of what they say. I think it should be fine. Dame wants to know, I filed for EB3 to EB2 interfiling. If EB2 I-485 gets rejected, is it possible to use EB3 I-140 and reapply I-485? It is possible, but I do not know your entire case. So if you have two I-140s, one is EB2, one is EB3, and your 485 is attached to EB2 and the EB2 gets thrown out for some reason, you can still use your EB3. Okay, so you can always file a new 485, or if the priority date is current, that is not a problem at all. Next question is need IMI. My priority date is Jan 2009 in EB2. It's current in September. I have travel plans. I want to go to India for a month in September. I've got my advance parole. Question number 1. Can we travel when priority date is current? Yes, you can. I have submitted medicals in Jan 2012. Is this still valid? No, they're going to ask you for new medicals. If you, yeah. I think it's a good idea to get your medicals done and leave them with your lawyers before you go. I have a G28. Do I get a copy of any RFE? I don't think so. I think only your lawyers will. In case if green card is approved when I'm in India, what documents I need to show? It's an interesting situation. Many of our clients have had that problem come up. And typically, there are two aspects to it. One is to get into a plane, you need some paperwork. That's where your advance parole comes in. You show the advance parole to the um, airline, they will let you in. Once you land at the airport, the CBP already has the information that your green card is approved. They will also look at the advance parole, but they should not create a problem with you getting it. Okay. Indeed says, I have seen your videos, Rajiv. I had a couple of questions regarding OPT STEM extension. Employer filed for H-1B, not selected in lottery. They want to file again next year. Since I don't have the work authorization on gap, I wanted to find out if there are any options. Okay, I see you are already on the 17-month STEM extension. Okay. So CPT, curricular practical training, is one option. The CPT has been a very poorly understood and treated procedure by USCIS. We see so many cases where people have used CPT to work and USCIS has denied CPT as being proper status. It doesn't mean it's the end of your H1. If you get selected on an H1 lottery and get approved, you will have to go outside for visa stamping. Anybody who's on CPT has a big risk, a huge risk that USCIS would consider them to have not maintained status. Okay, which is all right. It doesn't really hurt us eventually, but it does mean you'll have to go for visa stamping. Is it possible to go back to school and take CPT in the first semester? And the answer is yes. Would I lose OPT the day I start school? I don't think so. I don't think so. Is it possible to do volunteer work for the same company? And the answer is probably. Very difficult to answer this question, tough question to answer. As long as you're not getting paid any money in cash or in kind, including benefits. Is it legal? It may not be legal for the employer to take that work because the Fair Labor Standards Act does not allow internships without being paid. So immigration law may allow it of the employee, but it may not allow the employer to take that work. Any movement in the H4 spouses to get EAD by the end of this year? I just did a radio show about 20 minutes ago in which we did talk about it, and I think that by the beginning of next month, September, we should know better what the stand of Obama government is going to be. It looks like they're trying to help by increasing the number of green cards just by changing the way they count green cards. The estimate is about 80,000 more green cards. And they are trying to push through the H4 regulations for the EAD. Next question is from S Reddy 328. Two companies A and B filed H1B in April 2014. Company A's H1 is approved, but F1 to H1 is denied because CPT is not an integral part of my study. See, there's my point. When CPT, they don't think of CPT as being good status. Does that mean I am out of status? Yes. Do I have to leave USA? You should, because you should get your H1 visa stamped. I haven't seen the notice. Your lawyer should take a look at it. Don't send me the notice. Your lawyer should take a look at it. You have to worry about unlawful presence, because if the notice terminates your legal status and stay, in 180 days you become barred from entering USA for 3 years. Can I file motion to reopen by myself? Unfortunately, H1B motions have to be filed by the employer. Okay. Next question, USCIS, INS, DOL, GC. That's the long one. Okay. Wife and myself did a concurrent 485 and I-140 in April 2012 under EB2 filed in TSC. Then did a priority date insertion. I've received my latest I-140 with the old priority date. The case has been transferred now to Lincoln, Nebraska. So somebody said this could be a confusion between TSC and NSC. Should I take any action to get these cases transferred to TSC? No, I think what you should do is you should contact the USCIS customer service. Case redistribution happens all the time. USCIS does transfer cases from one center to another many times to redistribute the work. Okay, so I think you can call USCIS customer service, just make sure that the case is on track. Just ask them what the status is, where the case is. They should be able to give you more information. WNVX wants to change legal name going through naturalization in Newark, New Jersey. Both the first and the last name need to be changed. Do you know how much longer I have to wait if I go through the judicial ceremony in Newark? I don't know what the local court times are. Okay. And I don't know what the local procedures are. So you have to call the court, typically the General District Court, or whatever court is responsible for these in Newark, and ask them what the times are. The good news is most of the court systems tend to be quite friendly. Most of the court systems in USA. Although Newark, being a busy location, may not have a whole lot of time, you could always swing by the court, ask them your questions about what the procedure is. Do you have to go to court? How long it's going to take? I think it's a good point. If you want to change the names now, would be a good idea rather than doing it after getting naturalization. It'll be a lot more complicated, I think, in that case. A friend does not have, this is from, again, from WNVX, a friend does not have an account here. Accounts are free. You can even log in with your Facebook or Twitter account or Google Plus account. You don't have to open an account. Is it possible to ask for FOIA documents if one does not have any paperwork left to remind him of his A number? I have done FOIA requests with just the date of birth and social security number. Okay, I think that should work. So if you have the social security number, full name, date of birth, that should be enough for FOIA. But again, I haven't looked at this specifically. From what I remember, it was fine. Swapdeep says, I have a question. As an H-4 visa holder in the US and an Indian citizen, I plan on applying for Canadian permanent residence. If my PR comes through within a year, will my H-4 visa get affected or void immediately? No. I think you posted this message somewhere else also. For some reason, this message seems very familiar. So just because you've got Canadian permanent resident, your H-4 visa does not get revoked. And even if you move to Canada to work there, as long as your H-4 stamping is good, you can come and go as you please. You're still on H-4. So H-4 visa gives you the option but not the obligation to stay in the US. Okay. While applying for the PR, they asked for sufficient funds. Can I show my husband's funds and income as a source? I don't know. This is a question of Canadian law. Under US immigration laws, that's not a problem. Can people, Vikram KR, can people do Amway business on H-1B visa? Absolutely not. Can they file for a separate H-1B to represent Amway? I don't believe so. You can't get 1099s. You have to be on a W-2. Carol PT wants to know, I'm on F1 visa. I'm on OPT grace period. OPT won't start until October 2014. I got a job offer from a university which qualifies for 501c3. They want me to be on board immediately. I'm wondering whether I'm eligible for cap exempt H-1B. See, that, Carol, I can't tell you because the rules for who is and who is not cap exempt can be quite difficult. Because remember, it's not the employer who has to be cap exempt, it is the job. Sometimes you can be working for a cap employer, but the job supports the functions of a cap exempt employer, like in the case of a employer to contractor or contractor to end client situation. So even though the employer who's the contractor is subject to quota, the job that you are doing could be exempt from the quota. So talk to your lawyers. They need to review the entire job structure, the nature of the employer, whether or not they are cap exempt. I cannot comment. Okay. Can the H-1B be effective before September 15th if I go through premium process? I think September 15th is a little optimistic, but you never know. It could happen. So, but I mean, October 2014 is not that far away. Maybe something to think about. Naveen Chikodi wants to know, I'm on EB2 with priority date of June 2008, which is current since last month. I've applied for 485 in Jan 2012, and so my medical would have expired even though I'm current now. I don't have a medical RFE, nor do I have any approval. So I've opened a service request, took InfoPass, no luck. Finally went to a congressman and found out that the background checks are not completed for both my wife and me. How long does it take to get clearance? I assume you're talking about background checks. That's impossible to predict. The longest background clearance I have known is about 4 or 5 years. Okay, but most don't take that long, within a few months. Is there any way to expedite the process? Not that I know of. Okay. I would not advise filing a lawsuit against the government lightly. There are too many variables about lawsuits. It depends upon where you are, because the court's approach in Washington, D.C. may be very different than the court's approach in California. So you need to talk with a local lawyer or with a lawyer who can study the law of the state through which you want to file a lawsuit. Most of these cases, lawsuits are not effective unless quite a few years have passed. So currently, we are using EAD for employment. Can I get my H-1B reactivated as a safe measure? You can. If you step outside USA, get an H-1 visa stamping, or if you already have a stamping, just return back to USA on H-1. You can certainly do that. And that puts you back on H-1. Next question is from Imi Raz. Question regarding 485 filing. Approved I-140 from employer X. But when he went for visa stamping, case was under 221G for 16 months. Later, the visa was granted, but in the end, the H-1B petition was revoked in April 2014, 1 month prior to the expiration date. You stayed in India but returned to USA in January 2014 with employer Y, a top 4 consulting firm. So now I have an approved I-140 through employer X under consular processing. Should I continue the green card processing given the H-1B revocation? What are the chances of green card approval? Well, I'm a little hesitant to go forward with this case for a bunch of reasons. This is a rather short time. I will not be able to detail all the reasons, but two obvious reasons are: one, if an employer has a permanent job for you, which is the basis for a green card. Oh, I hope I have not disconnected. Let me just give me 1 second. 1 second. Let me just make sure I'm still being heard. Can you all hear me, guys? Can you all hear me? Hello? Hello? Can you all hear me? I guess not. Let me log back. All right, we are back online. Something went wrong and we were disconnected for a second. We are back again. Let me put you back on. Can you all hear me?
Yes, I can hear you.
Oh, okay, good. Excellent, excellent.
Hello, sir.
The conference is now in presentation mode. Your line is muted.
Why is my line muted?
Line unmuted.
Okay. Let me just make sure I've unmuted the right line. Okay, everything looks fine. So getting back to what we were talking about, so you've got a green card I-140 through one employer, the H-1 got denied, eventually revoked. The question is, should I continue with this green card? Two issues that bother me. One is the issue of permanent job. If there is a permanent job, who is doing it while you're not there? And the second issue is the ability to pay wages. So I'll be careful with this green card. I'm not sure it's a great idea. Really, somebody should look at the entire facts of your case, talk with your lawyers, make sure they understand what was going on with your case. And I'm not sure I can give you good advice without knowing more about the merits of the company. How big is it? How many employees do they have? What is the answer to the question? How can you do without an employee if this is a permanent job? And what is your ability to pay wages? All these things should be looked at. Okay. Maybe this issue will not come up. Maybe it will. Better to know that. Okay. Now, if you want to extend your green card or your H-1 actually through employer Y based upon the I-140 of employer X, as long as the I-140 is not revoked, you are fine in getting an extension through a different employer. So I don't see that as a problem. Okay. So what is the best course of action? I cannot really tell you. Only your own lawyers can tell you because there are so many variables in the situation. I can tell you what the potential issues are, and those are the ones I mentioned: ability to pay wages and the permanency of the job. Discuss that with your lawyers. Okay. Next question is from Reddy. I'm completing 6 years on H-1B, moving back to India September 2014. Am I eligible to apply new H-1B in April 2015 quota as I complete 1 year by October 2015 start date? No, that's not the way it works. Here, when you're trying to reset the quota, the date on which you apply for H-1, which is April, you must have already been outside USA for 1 year. It is not enough that on the date in which on which you're asking the H-1 to start, which is October 1st, you would have been outside for 1 year. The date you apply, you should have been outside for 1 year. Right now, this is their thinking. Tomorrow, I don't know. Jeannie, my husband's H-1B is due for extension in November. I am on H-4. Visa expires November 31st. Okay. They started an H-1B process for you. There was an RF fee and then a denial. Does this affect my H-4? No, it does not. As long as you did not start working. Okay. So the fact that you were on H-4 and the H-1 was denied does not affect your H-4. You are still on H-4. And you should tell your husband's employer's legal team to apply for your H-4 extension. That should not be a problem. We both have booked our tickets to visit India in December 2014. Can we premium our case? You can premium your case. That's fine. How bad does the H-1B denial affect me? As long as you have not committed any fraud, the fact that an H-1 was denied is not a problem at all. Don't worry. ABP regarding immigration visa. I-130 was filed for wife of US citizen. USCIS approved the case April 2014. AOS fees paid. DS-261 form completed. So still immigrant visa application fees is not invoiced. I am a little confused. You said AOS, that means adjustment of status. Are you in the United States? Have you converted to adjustment of status? Because If you are talking about NVC, then your case is not an adjustment of status. This is a consular processing case. So there appears to be some confusion here. I see a couple of people have raised their hands. I'm not done answering all the questions yet. Let me finish those, and then we'll get to the raised hands. So I'm not clear about what your case is, ma'am. I really don't know, but usually NVC can be reached through emails and telephones. I guess you keep calling them until you're able to get a response. Raja wants to know, current H-1B expires September 15th. This is my 6th year. I've got an EB-1B approval. My attorney advised to capture vacation time on current H-1B. Oh, no. This is a bad idea. You should never work without authorization. Absolutely bad idea. And this is very poor advice in my opinion. You should apply for H1 extension. Because you have an I-140 approval, you are entitled to a 3-year H1 extension. And once the H1 extension is filed before September 15th, when your current H1 expires, you can continue working for up to 8 months. By that time, you'll get your work authorization also. So that's the way to handle it. Okay? Now that's very bad advice that you just continue working without employment authorization. Don't do that, please. Notice of intent to deny received by Naren. Guys, be careful about putting your personal notices up, although you have hidden the information, but I would have just hidden the name too. So the notice is here on the screen. They want to deny I-485 because you went to India without first obtaining an advance parole, though advance parole was granted August 29th. So you went 13 days before it was granted. You applied and left. The only thing that can protect you is if you have an H1 visa. If you did not have an H1 or H4 or L1, L2 visa, I don't see what we can do. USCIS is right. And the last question is Prodigy 7035. I'm on J1 exchange visitor expiring end of this month. I have a waiver, but no job offer from academic or non-profit research organization to convert to H1B. I'm thinking of changing to B2 or F1. Can the request for change of status be made in grace period? A couple of things you need to check. I think grace period is okay. I have to double check that. F1 we know grace period is fine. But double check also, can you apply for change of status if you used to have J1, or are you required to go outside for visa stamping? I don't remember, but there's something like that somewhere. So please double check those two things. I think grace period point is okay, but double check it. You can call USCIS about it. And hopefully if the question is complicated enough, they'll let you talk to an adjudications officer. Okay, that said, first of all, let's see. Okay, there were 2 raised hands. I have lowered them. I first want to answer only follow-up questions, no new questions. So anybody who has a follow-up question, please press *5 on your phone. Press *5. Okay. Any question, old, new, press *5. Any question. Press *5. Those 2 folks who had their hands up, press *5 again, please. I hope you guys can hear me. Okay, let me just put the call in a conference mode.
All participants are now unmuted.
Can you all hear me, guys?
Hello, sir.
Okay.
When you put in presentation mode, we are not able to hear.
We are not able to hear you.
Oh, really? Okay.
It's been 20 minutes. It is free for past 20 minutes.
Oh, no, really? Okay, well, we have the recording. Let me see if I can fix that. Give me 1 second, okay?
You are now a host.
Thank you.
The conference is now in presentation mode.
I think now you'll be able to hear me. press *5 if you have any questions, new or old. Any questions? And if in the last 20 minutes when you could not hear me, your question was answered, just go ahead and press *5 anyway. I don't mind repeating myself if you did not hear the answer. We have it recorded, but any questions, new, old, follow-ups, press *5. I've got 3 so far. Okay. Well, I think, okay, 4. I will go in the order in which you people logged in, folks. So it's 5 people so far. So let's start with New York. New York, go ahead, please. New York.
Hi, Dalinji.
Hanji, hello, how are you?
I'm good with you. I think my question is, I recently got my approved via CPU processing in 2 category, and I got my attempt in the passport. So I've been here in US for this chapter.
Okay, hang on one second.
Hang
Hang on 1 second. Your voice is breaking up very badly. I cannot really understand. Either move closer to the phone or something. For some reason, I can only hear every other word you're saying. So let's start again, please.
Better now? Can you hear me?
Yeah, speak slowly and let's just see if we can get everything. Go ahead.
Okay. I recently got my green card approved.
Green card approved. Okay.
Through processing.
Okay. Okay.
Consular processing in B2 category.
Okay.
And I visited US for activation of my green card alone.
Okay.
And submitted all the documents at the port of entry.
Okay.
Stamp passport with an entry stamp.
Okay.
And I-551 visa, immigrant visa. And it's going to take 4 months to get a legal green card. He told me at the port of entry. My question is, with the visa and the other stamp of entry, good as a green card, that I can travel freely to the country.
Okay.
I intend to migrate in next 2 months. So during these 2 months, I would be traveling towards a lot of time.
Okay. Well, here's what I've understood you to say. Your voice was breaking up pretty badly, but here's what I understood you to say. You've got your green card approval, EB2 consular processing. You entered USA at the port. They told you you'll get your green card within the next 4 to 6 months. Your question is, can I travel in and out of USA on that stamp that I have on my passport? Is that correct?
Absolutely.
Okay. Here's what I want you to do. I don't know what your stamp is. If the stamp says, it should say that, processed for I-551, temporary proof of permanent residence. Is that what it says?
Say that. The immigrant visa is I-51.
I'm not so sure that's a multiple entry visa. I think what you should do, just take an InfoPass appointment, and go to USCIS. They will stamp your passport with a stamp that should be good for between 1 and 2 years. It will say, processed for I-551 or some such language, processed for I-551, temporary proof of permanent residence. That is as good as a green card. You can come and go as you please with that.
Okay.
All right? All right, let me go on to the next person. Louisiana, go ahead, please. Louisiana.
Hi, Mr. Raju. This is Raja. I couldn't hear you when you answered my question. I don't know if I can ask you.
Yeah, you can.
Repeat what
you can. Of course you can.
Mine was number 24.
Give me 1 second.
MRSCHAR. MR Shaker.
1 second. Did you say 24? Number 24?
Yes, number 24.
Okay. Oh yes, your lawyer told you to continue working without employment authorization. That is absolutely terrible advice. Okay?
Okay.
What you should do is apply for H-1B extension. Because you have an I-140 approval, you are entitled to a 3-year H-1 extension. Okay?
Okay.
So as long as your papers are received by USCIS before your current H-1B expires, which is September 15th, okay, you can continue working even while the extension is pending. So once a timely H-1B is filed, you have almost an 8-month extension to continue working. 240 days, okay? And by that time, your EAD will also come, so that's the right thing to do.
Okay.
All right.
Just a follow-up, I couldn't have it here. Will it be the same for H4 too, like for my wife?
Yes.
He said, like, for my wife, if we file for I-485 before 15, we don't need to renew that.
Actually, that is true. That is true. That is true. As long as her 485 is filed before her current H4 expires or within 180 days, she should be fine. So that's fine. But because you need work authorization, you have to go through the H1 extension.
Okay, because I need to be on the payroll and all that.
Yes.
Okay.
Yes. Okay.
Thank you, Mr. Rajiv.
Oh, you're welcome. You're welcome. Good luck, sir.
Thank you.
Okay, we just did Louisiana. Let's go. What is going on? Okay, let's go to Florida. Florida, go ahead, please. Florida. Tampa, Florida, go ahead, please.
Hello?
Yes, sir.
Am I audible to you?
Yes, you are. You are.
Okay. My name is Rupinder and I'm from Tampa, Florida. I have a couple of questions. Just need a clarification, actually.
Sure. Go ahead.
One question is, can I get my driving license renewed based on the receipt number? Because what happens is my I-797 is going to be expired in the month of November, first week. And my employer is going to file the extension this week or probably next week, and in the general processing. So most likely in general processing, it generally takes 2 to 3 months, I think, right?
It can take more than that. But let me just preface my remarks by telling you that driver's licenses are a matter of state law. I cannot comment what the law in Florida is, nor do I know what the law is. But if I were to make a guess, I would say that most states would require, they're not smart enough to understand that while the extension is pending, you are considered to be in status or authorized period of stay. They probably will not renew your license, but you can check with the local Department of Motor Vehicles. I would be surprised if they renew your license.
Okay, definitely I'll check with them. Second question is, if I file the H1 extension on premium processing after filing in the general processing, is it possible? Can I do that?
Yes. So the question is, once a case is filed non-premium, can it be premiumed while it's pending? And the answer is yes.
Okay. And the fees for filing the extension is afforded by the employer, not by the employee, right?
Well, the current thinking of the US Department of Labor is that everything related to the H1 should be paid by the employer. There may be an exception where an employee specifically requests premium processing for their own benefit. So premium processing fees might be the exception, but the Department of Labor usually wants the employer to pay everything.
Okay, I got your point.
All right.
And yeah, I got your point. And last question is regarding the tenure of the H1 actually. So I know that maximum they give 3 years of extension. What happens is myself and my colleague is into same project, one project, same client, everything is same. and he was like, his employer is different, my employer is different. But what happens is my employer files an extension in a lesser period, and his employer files the extension for maximum period of 3 years. He always get an extension of 3 years. My employer says, no, 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 we cannot do that. By law, we cannot do that because they might ask something for some documentation. Maybe your case may go into RFE. I understand that. But in both the cases, the documents or the contracts are same thing for 6 months or for 1 year. There is no exception in these two cases. But why does the employer think in this way that if they file in a maximum period and they can send a case into RFE? Rather than, I checked with the other one also, my colleague, he says that my case never went into RFE, though he is having a contract of only 6 months every time.
Well, that's a matter of luck. That's all. But usually, USCIS wants to see documentation for the entire 3 years. If you're asking for 3 years, if you have documentation for less than 3 years, they will issue you an RFE, which is not the end of the world. They issue an RFE, and if you cannot document, let's say, more than 6 months, they will only give you H1 approval for 6 months. So the fact that your friend is getting it is just a matter of luck.
Okay. Just last one more question. How long the firm is taking to get it approved?
The times are on our website. Just look at the times and status checks. I think it's like 6 to 8 months, something like that.
6 months?
I don't know. I'm just making a guess.
Okay. I'll just check it out. Thank you so much.
Please.
Appreciate it, Rajeev,
You're welcome.
for your answers.
Take care, Ji. Bye-bye.
Thanks, everyone. Bye.
Okay. Well, Louisiana is back in action. Let me just finish the other two questions first. Okay. Jersey City, New Jersey. Go ahead, please.
Good afternoon, Mr. Rajiv. This is Naren Venugopal. How are you?
Good, Narenji. How are you? You can just call me Rajiv.
This is question number 25, sir.
This is the notice of intent to deny. The problem is, because you left the United States 13 days before your advance parole was approved, I think you have a problem. Did you have an H1 visa stamp?
No, sir.
Yeah, so no. They are right. I think you have to file for 485 again once your priority date becomes current.
So does it mean that I will not be able to work?
Well, it's a little bit more complicated than that. I don't know all the answers. Of course, you will not be able to work. Well, you can be aggressive about that. Some lawyers will tell you until they actually revoke the EAD, it can still be used. But I think what they should look at, what is more important is, your lawyers should look at whether the fact that you had a 485 pending, but not full status, does it stop you from filing a 485 again? Or are you required to go outside USA, get an H1 visa stamp and come back and then apply for 485? So in other words, the fact that you have been on 485, which was no good, and it wasn't good since, let's see, since 2013. So you came back, when did you come back into the US? In 2013?
I came back advance parole, sir, last year.
Which date?
On October, around October 12th.
So that means definitely it could be an issue, because from October to now, which is more than 180 days, you have been on a 485, which was eventually found to be abandoned. So while you don't have any problem with unlawful presence for the past time, but you do have a problem with status. This is a technical issue. Your lawyers will be able to guide you through it. I'm not sure you can file a 485 without first going outside USA and coming back on H1 visa. So I don't think we can do anything for this case. I think this 485 will get denied. And I don't know for sure if you can file a second 485 without first going outside USA. Find those two things out, okay?
Because I went to India once again in the month of March, and I came back without any problem because I still have my advance parole was still valid.
You said March of this year?
So I went again this year, March of this year, and I came back in the month of May once again.
That creates another big question mark. Is the March entry a valid entry? Or in fact, even the October entry a valid entry because your 485 was already abandoned. So I don't have enough time here to, your situation raises a bunch of legal issues. Okay, not just one. There's at least 10 legal issues here that require a lot of discussion. Talk to your lawyers is what I would suggest. The easiest thing might be to just go outside USA, get an H-1 visa stamp, come back, apply 485 again. Okay?
So that if I had to file H-1B, that's only for next year, isn't it? Because nothing is available today, this time.
If you had an H-1 earlier, you might be able to take advantage of the 3-year extension available. So again, you had an H-1B before, right?
That thing I've already ran through the 7 years.
Yeah, but that's okay. As long as you are not outside USA for more than 1 year, I think you should be quota exempt. So double check
so that H-1B lot expired in the year of 2003, 2004.
Oh, that long ago.
Yeah, after that, I've only been filing EAD extensions every 2 years, and I'm on advance parole every time I go to India and come back.
Well, that's an interesting problem. Again, I really don't have enough time to go over your entire history here. I can answer simple questions, yes and no, and spend a couple of minutes with you. I got a couple of other people waiting. But this is a complicated situation. Don't rely upon a 2-minute consultation. Talk with your lawyers, figure out, number one, can an H-1 be extended? Okay, so you've never been outside USA for more than 1 year, but your H-1 was approved more than 6 years ago. Can you still qualify for H-1 quota exemption? I don't think so, but I can't remember off the top of my head if there's any provision in the law that supports the situation or the contention that you are quota exempt. Figure that out. Figure out, can you file 485 without leaving USA and coming back in first? That's very important. And the third thing which we talked about, I don't think there's any way to prevent this 485 from being denied. Okay, I gotta go on. Good luck. Okay, North Carolina. Go ahead, North Carolina.
Hi, Rajesh. My question is, like, I'm working for company A right now, and I got a job offer from company B, and the transfer and the premium processing is already approved, but the start date is September 8th. So, do I need to work till September 8th with company A?
So your question is, if I want to sit at home and not work at all, is that okay? And the answer is no. I think you will need to maintain status till the time you transfer over to the new company.
Yeah.
So you should be working.
Is approved from September 8th.
Yeah, but then you have to maintain. I think you have to maintain status all the way to September.
Oh, okay. So, okay.
All right.
So what is if I give notice to the company A and they will go ahead and they withdraw the H-1B petition before September 8th? Would I be out of status?
You can give them a notice. Yeah, that can become problematic. You can give them a notice. I guess this is a difficult situation actually, because legally, the sad thing is, if I, the employer, withdraw your H-1 today, even though USCIS acts upon it 2 months down the line, they date it back to the day I asked for it. Okay, so it's one of those situations where there's no clear legal answer. I think you'll be well advised to give them a 2-week notice if that's what you want to or have to give. And this is such a difficult question to answer. I don't think USCIS will make a big issue of it. But give them a 2-week notice, no more.
Okay, yeah.
All right?
All right, thank you.
You're welcome. And the last question is going back to Louisiana. Go ahead, please. Louisiana. Okay, I guess this was a leftover. All right, folks, it was good talking with you. We had a couple of snafus today. We got disconnected, and then the mute somehow did not work well. But we've got a recording. I'll be able. Hang on one second. I'll be able to put it all together, so the recording should be fine. Yes, sir. Go ahead, please.
Yeah. Can you hear me, Mr. Rajiv?
Yes, sir. I can.
Okay. I just forgot to ask you this, like, when you said for H-1B renewal for me, this is my second renewal with the firm. They did my transfer and they did my first renewal in 2011. This is my second renewal. And my attorney said, like, we don't need to do U.S. worker training fee and fraud investigation fee. I just want to and
I do not know. I don't go into those details. People in my office take care of that. My colleagues who take care of what the fees should be, I take care of the legal issues. I do not know the answer to this question.
Okay.
Okay.
I just want to know if that is true. Like
I don't know the answer.
Second renewal, we only need to do this.
I know that when you do second renewals, there are some exemptions. I don't know what the exact nature of those exemptions is.
Okay.
All right.
Thank you, Mr. Rajiv. I appreciate your time.
Good luck, guys. Thank you all for being here. I'll see you in 2 weeks, next Thursday. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.